let me talk to Ms. Ladd, Your Honor.
Okay. All right. So this is in the matter of the people of the state of Michigan versus Samantha Diane Ladd. File numbers 22-20962FH and 23-21239FH. And Rhonda Underwood appearing on behalf of Miss Ladd. So I'm going to open up a breakout room and pop you guys into it. All right, Mr. Van Meldigan will be with you in a minute, all right?
Yes, ma'am.
Thank you. So, Mr. Van Meldigan, I'm gonna pop you in the waiting room because
Okay.
you're talking to somebody. So, all right. So we're back on the record with Miss Ladd. Miss Underwood, you've had a chance to speak with Miss Ladd.
Yes, Your Honor. I also had the chance to look into the confusing note. Your Honor, Ms. White is working with Ms. Ladd on rehab, but what she needs for CMH is a document from the court that she can be released to rehab. So that's what's holding up the paperwork in this matter, Your Honor.
So what are you asking of me?
I guess if we're going to do a sentencing to rehab, that be put down, or, you know, because that's how they deal with releasing people from jail. When Ms. White does it, she goes through CMH and they that's their process. So we need something from the court, whether she's sentenced today or whether she's sentenced in the future, that she can be released even to rehab.
Okay. Inpatient treatment. So her initial, so she was originally sentenced on June 23rd of 2023 to a 3-year term of probation. The recommendation today is that, so Ms. Walsh, obviously Ms. Ladd is now trying to address some addiction issues and a rehabilitation program. Your recommendation is 1 year in the jail, revoke her 7411 status. And I don't think that's unreasonable, Ms. Underwood. Of a recommendation based on her past history, if I give her a chance to go to rehabilitation, if Ms. Ladd leaves that program, if she doesn't complete the program, if she gets kicked out of the program, and she doesn't continue with a better outlook on probation, we're going to be back here again, and Ms. Ladd needs to understand that. Or are you asking for her probation not to be continued?
Your Honor, I believe this was discussed the last time, and Ms. Ladd understands that she gets one chance. This was discussed at our last hearing.
Been in front of you several times and given several chances that I've taken for granted. And
hold on, Miss Ladd, hold on. I hate that room that you're in. It's the worst room at the jail. So scoot on up and give me just a minute, okay? So don't worry, you get a chance to speak. Give me just a minute. All right, anything else? So Miss Ladd, did you get a chance to read and review the probation violation report?
yes.
Did you get a chance to talk to Miss Underwood about it?
Last court date, yeah.
And then you were in a breakout room with her today?
Correct.
Okay. So you've been able to speak with her. Do you need to speak with her anymore?
I don't think so. I thought we already knew what we were doing by last court date.
Are you satisfied with Miss Underwood as your attorney and
Yes,
the advice that she's given you?
Yes.
All right, Ms. Underwood, is there anything you wish to explain or challenge in the violation of probation report?
I don't believe so, Your Honor.
All right, is there anything
you-
else you'd like? Hold on, Miss Ladd. That room just has really bad audio. That's all it is. So, Miss Underwood, is there anything else you'd like to say on behalf of your client?
Just that, as we discussed last time, and as Ms. Ladd really put to the court last time, she realizes that Ms. Walsh has done a great deal to try and help her. And she also realizes that she's taken it for granted. But I think this time in jail has really made Ms. Ladd be clear-headed and grow up. And she really wants the advantage of rehabilitation in this matter, Your Honor. We would ask that Ms. Ladd be approved for inpatient treatment, Your Honor.
Now, Miss Ladd, is there anything you want to say on your own behalf?
Just that you've given me several chances and I've failed at all of them and time again. And I would like to just get some different type of help, some actual help, and instead of sitting in jail, so I can get her to be a better mom. And this jail stay has been horrible. I wake up every morning, go to sleep every night, worrying about if she's taken care of, if her needs are met. And so I just want to have one more chance and assure you that I do better this time.
So, Miss Ladd, you know, those are the things everybody wants, right? And so you haven't done anything on probation. And I will say about Miss Walsh that she will go to great lengths to help people who want to help themselves. But once she's done that and you haven't tried to help yourself, she is not, you know, she is going to punish you and by violating your probation, whatever. So just, you know, I have immense respect for Miss Walsh and the length she goes to help people be successful on probation. So I'm going to give you one more chance. But if you don't do it this time, we're going to be back here and you're going to do a year in jail and you're going to lose your 7411. So it's a sentence of the court that you'll serve 1 year in the Lenawee County Jail. You can be released to an inpatient program that'll be on both files.
So I am going to do the year.
Actually, hold on one second. Hold on. No, I'm going to release you to a program. So like if a bed's available in a week or two, you'll be able to go to that program. So I'm looking for jail credit. Hold on. All right. So I'm going to give you a year in jail on file number 23-21239. I'm going to release you to a rehab program. Your probation will be amended that you're ordered to complete successfully that program. If you hate it, you don't get to leave. If you don't like the people there, you put a smile on your face like I do every single day dealing with lots of people we don't necessarily like, and you do the program. You don't get kicked out. You don't get in a fight. You don't sneak drugs in, whatever. You behave yourself, complete the program, get all that information to help you be successful. And then I will continue probation. I'm going to give you credit.
It's an additional 20, I'm sorry. It's an additional 7 days from
So
the last
121 days.
Yes.
121 days credit on file number 22-20962FH. I'm going to give you 29 days credit on this violation of probation. And that's time served on that file. And probation continued. So you got a year to take advantage of this program, to take advantage of the opportunities Ms. Walsh has tried to provide to you. You know, Ms. Ladd, I know you don't want to end up where you ended up when you were a kid, right? We want to make those changes for our babies. So Now you do have the right to appeal this sentence, and my bailiffs, or no, the jail is gonna give you a notice of right to appellate review on each file, and just initial and date one copy for our records. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Ms. Walsh, instructions for Ms. Ladd.
You need to contact me as soon as you're discharged from treatment, or if you leave treatment. Either way.
Okay.
Judge, I'm sorry, what docket did you give the 1 year on?
I give her 1 year on file number 23-21239.
Okay.
But she can be released to treatment, correct?
Yeah, now who's arranging that?
Excuse me, Emily White is, I guess the only thing she was missing was, something saying okay from either your office, Your Honor, or Ms. Walsh's office, is how I understood it. 'Cause
It'll be worked out.
But
No, they're good. Are you talking about the treatment program?
yeah, Emily was already here to speak with me. She just needs something saying from, I believe it's your office, Ms. Anzalone, or Judge Anzalone.
Emily, who does Emily work for? Your office, Miss Underwood?
Yes. And now
So
that she has
Emily works for the public defender's office, and she's the one that sets up the programming. So it might take up to a week as soon as a bed's available, okay?
Okay.
All right, so good luck to you, Miss Ladd. And hopefully next time I see you, we'll be in a good position, right?
Yes, ma'am.
Anything else, Miss Walsh?
Miss Ladd, when you get to a program, I need you to please try to remember to sign a release of information for me.
Okay.
Okay?
Okay.
Okay.
All right, good luck to you.
All right, thank you.
Thank you. All right, Ms. Underwood, I have Mr. Van Meldigan.
Thank you, Your Honor.
All right. And remove that room. That is
Yeah.
The worst room. All right, so, Mr. Van Meldigan, why don't you unmute your device and start your video for me, please? So this is in the matter of the people of the state of Michigan versus Jeffrey John Van Meldigan, file number 19-19709 FC. This is the date and time scheduled for a violation of probation sentencing. Mr. Van Meldigan, did you get an opportunity to read and review your pre-sentence report?
Yes, I did, Your Honor.
Oh, good. And have you had an opportunity to review that with Miss Underwood?
Yes, I have, Your Honor.
All right. Are you satisfied with Miss Underwood as your attorney and the advice that she has given you?
Yes, Your Honor.
All right, Miss Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
The only thing we would like to challenge, Your Honor, is the pre-sentence report says that Mr. Van Meldigan didn't report at all. Mr. Van Meldigan, I believe, reported in Ohio for a significant period of time. And then there was a point where I believe he went to jail, and after he got out, he never reported again. Is that correct, Mr. Van Meldigan?
Yes, Miss Rosewood. Yes, ma'am.
Okay.
He wants to make it very clear he did not take his probation for granted this whole time. He really didn't. I recognize the recommendation in this matter is for a year in jail. I am hoping that the court would see fit not to give him that total year in jail, Your Honor. I do think that, yes, he deserves punishment for his violation. The court has to take these matters seriously, but I'm hoping that he would not get the whole year in jail, Your Honor.
Mr. Van Meldigan, is there anything you'd like to say on your own behalf?
No, thank you. I just, sorry that I did that to the court and Mr. Thomas Parker, you know, having to waste your time, come back to me. You know, and I know I messed up, and I'd just like to say thank you for everything, and that's all, Your Honor.
Okay, so Mr. Van Meldigan, prior conversation indicates that you did report to Ohio a couple times after we tried to transfer it there, correct?
A bunch of times, almost 18 months.
Mr. Moore, were you able to verify any information with Ohio?
Okay, yeah, there's where the confusion's coming in here. If you look at the report, he stopped reporting after his release from jail the second time. Originally, when we looked at it, and then I got back into it, look, yes, correct. I transferred his probation to Ohio. He was reporting down there. He then was arrested on an old felony warrant brought up here to the Lenawee County Jail, where he was struggling with some substance issues. So when he was released, then we never did see him until now, since
That's
2023.
September of 23.
Correct.
All right. So he reported for a while, and then after September
Correct.
of 2023, we never saw him again.
Correct.
Okay. All right. So that we talked about that before, Ms. Underwood, and that has been noted in the report.
Okay.
All right.
Mr. Van Meldigan just wanted to make sure the court was aware.
All right. So, well, Mr. Van Meldigan, you weren't incarcerated September of 23, were you?
No, ma'am.
Okay.
No, Your Honor.
So, all right. And so I appreciate that you did report for a while, but then eventually you did stop reporting completely for almost 2 years. So, it's a sentence of the court that, you will serve 1 year in the Lenawee County Jail. We'll give you credit for 7 days already served. I guess you have a current case in district court for possession of methamphetamine. We'll give you credit for 7 days and discharge you unsuccessfully from probation. Now, Mr. Van Meldigan, they're going to hand down to you, or somebody's going to give to you a notice of right to appellate review. Just fill out the initial and date the form. One copy will come to me, the other copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right, good luck down in district court, Mr. Van Meldigan.
Thank you, Your Honor. Thank you, Mr.
Thank you.
Rosewood. Thank you, Thompson.
Thank you.
I have to say the closed captioning that I have now on my system, so people can turn on closed captioning on Zoom, doesn't always track appropriately like what you're actually saying. So. No. They are? No. You'll get yours. I was just showing you.
Yes, they're beautiful.
I think that when you graduate from high school, they should still do the nice looking headshot. We can order it through the school,
Right.
you know, with your name and the year on it.
Yeah.
And they don't offer that anymore. So you get your senior pictures done by some independent photographer,
Right.
and then
Yeah,
you gotta print them, but there's nowhere to print them
exactly.
nicely, like,
Yes.
you know,
Yeah.
so.
Remember, you might have done, I never did these, but I always thought they were so good. Were the ones, especially the ladies with the black dress, you know, and the kind of.
Oh, with the pearls.
Yeah.
My mom's senior picture, she's like this. She's got a big bouffant, you know, her pearls, and
I just thought those were so.
those are
nice.
always pretty.
Yeah.
Yeah. Hi, Mr. Hartung.
May I approach her?
Me?
Mr. Bennett, Mr. Millar.
To talk to me?
Yeah.
All right, I'm gonna put the courtroom in the waiting room.
Don't know why I'm here, Brian.
I don't know, you did something wrong. All right, Mr. Rymer and Mr. Millar, why don't you step up there? Mr. Moore, this is also a Miss Teskey file. So, yeah, you can sit down if you want. All right, this is in the matter of the people of the state of Michigan versus Shane Leroy Rymer. We have multiple files, 23-21665. Well, no, we have one file, 3 counts. Today is the date and time set for sentencing in this matter. Mr. Rymer, did you have is the microphone down there? Yeah. Mr. Rymer, did you have a chance to read and review the pre-sentence report? You got to speak up for me.
Yes, ma'am.
You got to speak
All
up.
right, Mr. Malawi, he's going to have to stand at the podium. He's soft-spoken. It's okay. Okay. I mean, as long as he stands there, I'm fine. So attorney is always really loud. So you got to read and review the pre-sentence report? Okay. And are you, did you have a chance to discuss it with him? Okay. Are you satisfied with him as your attorney and the advice that he has given you? Okay. Mr. Malaro, well, first, Mr. Banetto, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Just some of the OBs, Your Honor, whenever the court feels that that's.
No, I'm not there yet. Yep. But anything else? The only thing I would say is on page 1 of the probation violation recommendation, it does say he pled guilty to those counts, and we'll amend that to reflect
Judge, I don't know that there's a probation charge.
pre-sentence report.
You said probation violation.
Okay, but pre-sentence investigation report says he pled guilty. He was actually convicted at trial. Okay, so Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
The factual information, no, we would not change.
Okay, so I'm not talking about the guidelines yet. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? I show he has no prior misdemeanors and no prior felonies.
We would agree with that.
Do you agree with that as well?
Yes, Your Honor.
Okay, so now we're going to talk about the guidelines. So Mr. Malaro filed a timely sentencing memorandum back on May 13 of 2025. I did not have a response from the prosecutor's office, but Mr. Banetto was kind enough to come up today. And so we had an opportunity to go through the guidelines using my copy of the State Appellate Defender's Office annotated sentencing guideline manual and discuss those guidelines. So Mr. Malaro, the first, if you'd like to start OV by OV.
Sure, Judge. Judge, with respect to the.
So let's start with the count 1 conviction of police officer assaulting, resisting, and obstructing, causing injury. Mr. Moore, there will be some changes to these.
So, Your Honor, with respect to OB3 on that file, we objected to the scoring. The basis was outlined in my sentencing memorandum on paragraph 4. And since it was, I believe that's the one where it's required to be an element of the sentencing offense. And since it is, I don't believe it should be scored. It should be scored 0. As to OB12, that one we scored at 5. We objected to that due to the contemporaneous element. And I emphasize if both of the following circumstances exist. So that it would be argument that should be scored as 0 as well. It's our argument that on that charge, the PRVs are correctly scored at 10, but the OBs, it's our argument, should be scored at 0. I think if that accepts that argument,
All right.
then the guidelines go to 0 and 9.
All right, so Mr. Banetto, with regard to OB3 on the RNO causing injury, what is your position at OB3 being scored at 0?
Your Honor, I would defer to the court's discussion on that. We did have off the record discussions. I'm not sure how that would apply as it relates to OB3.
Okay, so OB3 in this case is physical injury to a victim. It was scored at 10 points. it was originally scored at 10 points. Bodily injury requiring medical treatment occurred to a victim. We did have a discussion about that. And in this case, we did not feel OB3 should be scored at 10, but instead 5 points because there was no medical treatment required in this case. He saw a doctor, but there was no treatment. And bodily injury is an element of this count. So 5 points could not be scored. So OB3 was we scored at 0. And then we had a conversation about OB9. OB9 is number of victims. In this case, Mr. Malaro, I think you didn't address this one in your memo, but Mr. Bayonetto brought up he felt OB9 on this count would be properly scored at 10 because 2 to 9 victims were placed in danger of injury or loss of life. There were 3 police officers present that day, no charges continued for one of them. So that left us with 2 police officers involved in the incident. So I did score OB9 10 points. Mr. Malaro did object to that.
And we still did good.
Oh, thank you. And then OB12 is our next one. And OB12 is contemporaneous felonious criminal acts. It was scored at 5 points. Contemporaneous felonious criminal act involves 2 things. One, if the act occurred within 24 hours of the sentencing offense and will not result in a separate conviction. So I believe you had no objection. Is that the one you said Mr. Malaro was correct in?
Yes, Your Honor. I would stipulate that Mr. Malaro is right. And OB12 should be scored at 0.
All right, so we will score that at 0. So the PRVs remain at 10. The OVs will be 10, which the guidelines would remain at 0 to 17. So let's move on to the resisting, obstructing a police officer without the injury element. And Mr. Malaro, I believe your objections were the same. So do you wish to address them on that count?
Judge, we would just reiterate our objections as to OB3, OB12, and OB9 as well. I mean, the argument's the same,
Okay.
and I think the result, right?
All right. And Mr. Bandetto?
Your Honor, I will again stipulate to OB12 being scored at 0 and for the court's discretion as it relates to OB3.
Okay.
OB9 is scored correctly as it was in the last count.
All right, thank you. So there were 2 police officers and 2 RNOs, one involving an injury potentially. OB3 on this one was scored at 5 points for bodily injury not requiring medical treatment, but that was addressed in the count 1. So on count 2, there was no bodily injury to this officer. So OB3 will be scored at 0. OB9, the court believes that was correctly scored again for 2 to 10 victims. So I will leave OB9 at 10 points. OB12 again is contemporaneous felonious criminal acts. In that case, it doesn't exist in this file, so that will be scored at 0, which takes the PRVs would remain at 10 and the OVs will now be 10. So the guidelines will be changed to 0 to 11 months on this, and all objections are noted. So is there anything else to address with regard to guidelines?
No, Your Honor.
All right, Mr. Bayonetto, is there anything you'd like to say on behalf of the people?
No, Your Honor, thank you.
All right, Mr. Malaro, is there anything you'd like to say on behalf of your client?
I would, Your Honor. As I've indicated in chambers, I monitored this case pretty much from the beginning. As the court noted through the trial, Mr. Rymer, and he indicated, I think, at the opening of his trial that he was intoxicated. This revolves around an alcohol issue on Mr. Rymer's part, and I think directly relates to his behavior. That said, he exercised his constitutional right to a jury trial. The jury heard all the evidence and the jury made its decision. And regardless of Mr. Raymer's behavior prior to that point, this court appointed our office, as the court knows, Mr. Raymer represented himself, so I know he's been cautioned repeatedly not to do so. He accepted the jury's decision. The court appointed us for the sentencing. And when I went to speak to Mr. Raymer a few days later, I would tell this court that Mr. Raymer's behavior was a 180. He was contrite. He'd accepted the jury's decision without question. And I think that's what he was looking for, was to have a jury of his peers make a determination of what occurred. And since he's been in jail, I've talked to him a couple times. He has attended regularly classes at the jail. He completed an anger management class at the jail. He initially, and I told the court this in the back, and I think Mr. Raymer probably saw my reaction when I spoke to him a few moments ago. He said he'd been looking at legal books and works, and I thought, oh. And what he indicated to me kind of surprised me, because he said what he indicated was he had completely missed the boat as to how to behave and act in court, how to dress in court, how to address a jury, how to address the court. And he realizes, I think, the error of how he conducted himself and how he conducted that trial. With that said, Your Honor, I would ask the court to consider this as a sanction for Mr. Raymer. One, based on his ability to recognize what occurred and that the acceptance of a jury's decision in this matter. I don't believe, and I would ask the court to consider not imposing any additional jail time, but to impose a probationary term for Mr. Raymer. And the reason I say this is for several fold. First, Mr. Raymer does not possess a high school diploma. And I think with proper supervision, he could obtain that. And I think we all know, sometimes we take it for granted, but getting of the minimum of a high school diploma opens a lot of doors. Second, I think a term of probation would almost always, I've seen, involve him obtaining employment. And I think if Mr. Raymer can obtain employment, that also will help him along a path of being a productive citizen, as opposed to where he's been at. And I think that probably contributed towards why he's here today. And third, I think a term of probation would also assist Mr. Raymer, although he's been sober now for quite a while, but maintain that sobriety. So I think with those three components in place through supervision, this Mr. Raymer could go on to become a very productive citizen. And one thing I would note, there's no shame in this for Mr. Raymer. He can read, but I think he has some reading comprehension issues. And hopefully the probation department will take that into account if the court were to put him on probation when monitoring his progress. I am, and I don't get to say this very often, I didn't have much expectation or hope for Mr. Raymer when I first began to monitor his case and the times I spoke with him. But I do know, I think he is totally realized that where he was is not where he wants to be, and sees that with some help, and there's no shame or anything wrong with getting the help. I think that's part of what the probation department's purpose is, that he can become a productive member of society, and perhaps even get to a level where he could be perhaps a leader. And I think that would be a remarkable transformation. So I'd ask the court to consider not imposing any additional jail time. The court could always impose something later if Mr. Raymer cannot follow through. So that would be our request.
Okay. Mr. Rymer, anything you want to say on your own behalf? So Mr. Rymer, I watched the video. You're not necessarily a soft-spoken person. I know it's kind of overwhelming being in a courtroom, but we have to be able to record what you say. So speak, attorneys are loud by nature. We all are. That's why we became attorneys. But you just got to raise your volume so we can record this, because if you appeal the sentence, we need the transcript, okay?
Yes, Your Honor.
A little bit louder.
Yes, Your Honor.
Good. All right. Go ahead, Mr. Rymer.
I'm in agreement with Mr. Malaro on what he said.
That's it? All right. So Mr. Malaro and Mr. Bandito, I have a question. If you look on page 1 of the pre-sentence report, I forgot to address this with you in back. Pending charges, domestic assault 4th degree, OWI, resisting arrest, assault 4th degree. What's an assault 4th degree?
Out of Missouri, Your Honor, I have no idea.
Yeah.
They're all misdemeanors as far as I know.
So these are misdemeanors in Missouri that are just hanging out there.
Looks like it.
Okay.
Mr. Sears looked into them, and I don't know if Mr. Rymer absconded from Missouri or what, but there is a warrant pending for him for those.
Okay, thank you. All right, so Mr. Rymer, you did actually represent yourself at trial. And one of the things that even the prosecutor said afterwards is that for someone with no legal education and training, you did a good job. You behaved appropriately during the trial, you asked appropriate questions, and you interacted with both the jury and witnesses appropriately. So I do want to commend you, because that shows you have the ability to present yourself properly and restrain inappropriate behavior. So I do want to say that even the prosecutor said he did a really good job. Not as good as an attorney would have done with the training, but for someone pro per, you actually did a good job. And so, and when the conviction came down, you took it and you didn't behave inappropriately, which a lot of people do in this courtroom. So I also commend you on that. So it sounds like from your attorney that you have appropriately used the time that you've been incarcerated to read up on things and to gain more knowledge, and also think about what brought you here today. And because there was a body cam video, I got to see your parents, and I believe your grandmother, interacting and their comments, and you're on a path to destruction, right? Whether it's cirrhosis of the liver, something, you are definitely on a path to your destruction, and nobody deserves that. So I hope that you are wholeheartedly serious about trying to change the path you're on. And, I have a daughter who has a reading disability. It's not a big deal if you have one, but Adrian Ray Literacy Center at the Dominican Sisters, they have classes to help with that. We have different programs to get your GED to help you with that. And I'm glad that these are things you want to take advantage of, because if you don't change your life now, you're going to end up dead, dying, or in prison. Those are your options if you do not make these changes now. Do you understand that?
Yes, Your Honor.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication of the law, and the protection of society. I am going to give you that opportunity that you are asking for, okay? So I'm going to place you on probation for a period of 3 years. And during that term of probation, you are not to use alcohol. You're not to use any illegal controlled substances. You are to take medication as recommended and as required. You can't possess any, like I said, any illegal controlled substances or paraphernalia. You may be asked to go get a substance abuse assessment. And when you do that, be honest about your addiction issues, because you have some addiction issues. It's okay. Lots of people do. The difference is wanting to do something about it, which it appears you do. I'm going to ask that you complete your adult education or GED program. We have great programs in our community to help you with that, to work at your own rate. You must not engage in assaultive, abusive, threatening, or intimidating behavior. The probation department can enter your home at any time for probation supervision to make sure you live there, to make sure you don't have alcohol or illegal drugs in the home. You must report any arrest or police contact, loss of employment, change of residence. You're on disability, right? No? Okay, you're gonna have to get a job and maintain full-time employment at least 30 hours, all right? There are jobs out there, and we have lists and lists of jobs. You must pay a crime victim assessment fee in the amount of $130. There is a $30 per month supervision fee, or $60 if we have to put a tether on you. I'm gonna order court costs in the amount of $750. There's a $60 DNA test, and there is $136 state costs for the 2 felony counts, and then $50 on the disorderly person count. You're to report as often as required and obey and comply with all articles of probation. So I'm assuming that you're not in a position where you think you need an inpatient program at this point because you've been incarcerated for over 6 weeks.
I don't know what that means.
So sometimes when we have people with alcohol or substance abuse issues, they need to go to like an inpatient treatment program.
Yeah, I've been sober I've been sober since that incident, so.
Right. Okay, good. So you may be ordered to do outpatient treatment. You got to do it, all right? I'm going to put a curfew in place from 10 p.m. to 6 a.m. unless it's your employment that requires you to be out after that. And I'm going to give you credit for 49 days already served on this file. Okay, I'm not going to give you any more jail. You're going to get out today. And then that's on count 1 and count 2, all of that. And then on count 3, as I said, there's a $53 state cost. I said 50, but it's moved up to 53 now. And then $75 crime victim assessment fee, and I'm just going to give you credit for time served on that one. All right, 'cause it's a 93-day misdemeanor. Okay, so Mr. Rymer, you know, your family's here because they love you, but they're kind of at their wits' end with you too. You know what I mean? And they want you to have good things. And I think they love you very much. And so you've got a lot to live up to. And I think you can do it. All right. All right. Mr. Moore.
Yes.
He's going to be released today. What are your instructions for him?
Okay, I want you to report up to the probation department. Okay, and if Agent Teskey isn't available, you're going to schedule an appointment with the secretary there to have a meeting with her. Okay, so make sure you report, let them know who you are, why you're up there, and Agent Teskey's who you're going to schedule an appointment with if she's not available. Okay.
Does she need to report on Tuesday or whatever day they give her?
Well, I want him to come today to come up to the office and make sure we have it, you know.
Okay, so when you get out of jail today, they're closed from 12 to 1 for lunch, but you need to report to the 3rd floor probation department. They're going to set up a time for you to go over your probation terms with your probation officer. Keep a copy, know them, because you can't come back later and say, I didn't realize that, okay? And then they'll set up a schedule for you to report on, all right? And that means no alcohol, so you don't get to celebrate by getting out of jail by going to have a drink, all right? Okay, now you do have the right to appeal this sentence, so my bailiff's gonna hand down to your notice of right to appellate review. He's gonna have you initial and date 1 copy. Today is June 5, and the other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days or drop it off, all right? All right. Anything else, Ms. Adams? I don't think so.
I don't think so.
All right. Mr. Jagermer goes in, your guy's not in custody, right? Is he here?
He should be on Zoom.
He's not been on Zoom all morning. Want to call him? Yeah. I've had nobody in my Zoom waiting room. All right. Mr. Coast, are you staying on for Deolan?
I am, Judge.
Okay, so this is in the matter of the people of the state of Michigan versus Joshua James Deolan, file number 25-22183 FH. I am Michael Dagger-Margosian appearing on behalf of Mr. Deolan and Tom Moore from MDOC and Darren Coast for pretrial services. So he obviously appeared for the pre-sentence interview. We do have a report generated. Mr. Coast, do you have an update on him?
I do, Judge. He did have a contempt back in April. He tested positive for meth on 4/7. But since that time, he's done a really good job. He's been seeing me twice a week, every Monday and Friday. And ever since that positive, I haven't had any additional positive meths. So with that, I'm okay with the contempt being dismissed.
Okay, so I'm not going to dismiss it today, but I know that Mr. Dagger-Margosian has reached out to his client. Usually if they show up for the PSI and they're testing well, this seems to be an accident. So Ms. Adams, could I get the next available sentencing date, please?
Judge, that would be June 12th at 8:15.
Are you available that day, Mr. Dagger-Margosian?
I am, the only thing I'll add, Your Honor, is, I did speak with Mr. Deolan yesterday, and in passing, he said that he had like a bench warrant, he's on probation downstairs, and he had a bench warrant, but he was told that that wouldn't result in an arrest. The only thing I can think of is maybe he misunderstood that, so.
Okay, all right, so I'm gonna adjourn it to June 12 at 8:15. Just get him in here and we'll deal with it. Is that a new case downstairs?
No, he's on probation down there, so it's already been.
I have no authority or control over district courts,
I
so,
know.
all right, but, there's not a recommendation, let's see here. You know, this one's fine, so, yep, just tell me to get in here. All right, thank you very much. Thanks, everybody.
Thank you, Judge.
Thank you, Your Honor. I'm back.
All right, so Mr. Billingsley, if you'll come on up for me. So you can come on up to the computer. That's the best way to hear you and see you.
Okay, thank you.
All right, so I'm gonna put Mr.
And Your Honor, so Mr. Billingsley is aware the state would offer to reduce his speed to 80 and a 65.
All right.
And the state would offer to reduce his ticket to 80 and a 65, and it'd be a $100 fine if Mr. Billingsley would like to take that offer.
Mr. Billingsley?
Got reported on my license.
It would be, sir. It's 15 miles over, so it would be reported.
No, I'm going to court. I'm going to trial.
All right. So Mr. Billingsley, can you see Mr. Tipton?
Yes.
Can you hear me?
Is that the DA, Mr. Tiffany?
It's the solicitor, yes.
Yes, okay.
All right, so this is case 2024 TK 00106, Louis Edward Billingsley. You're before the court for speeding 16 to 20 miles per hour over the limit. Mr. Billingsley, Ms. Johnson, I'm sorry, let me try that again. So Mr. Billingsley, the state has the burden of proving the case against you beyond a reasonable doubt. You do not have to provide any evidence or testimony. You do not have to testify in any way or present any witnesses, but you do have the right to ask questions of any witness brought by the state. So what that means is you wouldn't make any statements, but you would just ask questions about their testimony or about the situation so that I would be able to understand understand what it is you want me to know about what happened. So let's try to avoid making any statements or saying things like, well, really what happened was, or what I observed, because you have the right to remain silent. And until you decide to give up that right to remain silent, then we don't want you to make any statements and jeopardize that right. You understand?
Yes, ma'am, I do.
All right. So the state's going to present their witnesses. After they finish questioning the witness, you'll be able to question a witness, and then we'll go from there. At the end of the trial, whether you make a statement or not, whether you wish to testify or not, each side will be given the opportunity to make an argument to explain to me why I should rule in your favor. Okay?
Yes, ma'am.
All right. So, Mr. Tipton, call your first witness.
Yes, Your Honor. State's going to call Officer Jeremy Parks.
All right, Officer Parks.
Good morning.
Good morning, Officer Parks. I got that, Mr. Billingsley. Hold on just a second for me. Officer Parks, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
I do.
All right, you can put your hand down. All right. Mr. Tipton, your witness.
Yes, Your Honor. Officer, would you please state your name for the Zoom call?
It's Officer Jeremy Parks with the Clayton County Police Department.
How long have you been with the Clayton County Police Department, sir?
A little over 3 years now.
And what's your official title?
I'm a field training officer.
Okay. And as a field training officer, are you post certified?
I am.
And being post certified, are you authorized to issue citations and make arrests and investigate crimes?
I am.
Okay. So when did you become certified?
August of 2022.
Okay. So I want to draw your attention to December 21st of 2023. Were you working with Clayton County PD?
Yes,
Were you post certified at that time?
I was.
Okay. And you have to do a certain number of hours to keep that certification up. Is that correct?
Yes.
Okay. Were you up to date at that time?
Yes, I was.
Okay. Okay. So did you have occasion to, well, let me ask you this. What were your duties that day?
Answering calls for service and traffic enforcement.
Okay. Did you have occasion to perform traffic enforcement on I-675 near Highway 42?
I did.
Okay. And during that, at that location on that date, did you have occasion to make contact with Mr. Lewis Edward Billingsley?
I did.
Okay. And do you see Mr. Billingsley on the Zoom call?
I do.
Can you identify him by an article of clothing he's wearing?
He's wearing a yellow shirt.
Okay. Thank you. So why did you make contact with Mr. Billingsley?
So I was traveling southbound on I-675, right at the Forest Park, between Forest Parkway and Highway 42. And I observed a vehicle traveling at a very high rate of speed. The speed limit being 65 miles an hour on 675. I got behind the vehicle and caught up to him, and I was able to pace his speed at 90 miles an hour. And then I conducted, a traffic stop by activating my emergency lights and pulling him over to the right shoulder.
Okay. Was your speedometer working that day?
It was.
Okay. How did you know it was working?
It's tested through Clayton County's maintenance program.
Okay. Okay. And was this portion of I-675 within the boundaries of Clayton County?
Yes.
Okay. And when you made contact with Mr. Billingsley, did he make any statements to you?
He did. I explained to him the reason for the stop, and I told him that I had paced him doing 90 miles an hour, and he said, no way I was doing 90, I was doing 85. And I said, well, the speed limit is 65, sir. And he said, oh, it's 65 here? I thought it was 75. And I said, no, sir, it's 65. And then I went to my car and I wrote him a speeding ticket for doing 85 miles an hour in a 65 mile an hour zone. When I returned to give Mr. Billingsley the ticket, he said, I hope you know what you've done. I'm a CDL driver. This is going to mess up my career. And I explained to him that as a CDL driver, you have to know better. And I told him to have a nice night and drive safe.
see. Okay. Thank you. At this time, I have no further questions for you, sir.
Mr. Billingsley, do you have any questions for Officer Parks?
I do.
All right, you may ask those questions. Ask them one at a time, allow him to answer, and then proceed with your next question.
Okay, Officer Parks, hello, how you doing?
I'm fine.
When you got on the interstate, were you coming on an on-ramp to the interstate?
I did get on the interstate from an on-ramp, yes.
Yeah, and what ramp was that?
I don't recall.
It was 2.
Objection, Your Honor, that's
Okay,
testimony.
so Mr. Billingsley, that's testimony. That's what we were cautioning you about. You can't tell him what to say, but you can ask him questions to elicit his response. And if he doesn't know, he doesn't know, so.
Okay. Well, could you see, you saw me when you got on the ramp?
I don't believe I saw you from the ramp. I believe I saw you as I was driving on 675 southbound.
Do you believe I could have seen you from where I was?
Objection, Your Honor, calls for speculation.
Overruled. You may answer that, Officer Parks.
I can't speak to that. I don't know. I wasn't stationary on the interstate. I was driving to another place on the interstate when I observed the vehicle driving at a high rate of speed.
Okay. When you pulled me over, what was the first thing you said to me?
Hey, how's it going, man? I'm Officer Parks of the Clayton County Police Department. I stopped you because I paced you doing 90 miles an hour in a 65-mile-an-hour zone.
Okay. Your Honor, the conversation was a little bit different.
Okay, so Mr. Billingsley, if you're done asking questions of Officer Parks, then allow the state to finish presenting their case. And then if you wish to testify, I'll go over with you your right to remain silent and whether you're willing to waive that right. And then if you do waive that right to remain silent, then we'll hear your testimony.
Oh, okay. All right. Okay, Officer Parks. Okay, after you gave me the ticket, how did you give me the ticket?
What are you asking? I'm sorry.
What kind of a ticket did you give me?
I gave you a written citation on our Brazos e-citation machine.
It's like a phone?
Yes.
And I just signed the phone?
Correct.
Okay. After I got back on the interstate and you got back on the interstate, did you get off on the next exit?
I probably got off on either exit 1 or 2 because that's the end of our county.
How far were you on the interstate from the time you got on it to the time you got off of it?
So Clayton County runs from exit 7 to exit 1. So that's the length of that's how far I would have went.
Okay. So if I was to say you were on exit 2 to 1, how far would that distance be?
From 1 to 2, I don't know.
Okay. Would it be a mile? Could it be a mile?
It could be, but I don't know for certain.
Okay. How much time do you, in the training that you've had for pacing somebody, how much distance do you need to travel to accurately pace somebody?
There's no set distance.
No set distance? Okay, let me ask you something. What's more accurate when you're gonna give somebody a ticket? Is it radar, laser, or pacing? Which is the most accurate way to give somebody a ticket?
Your Honor, this is irrelevant. The officer's already said he's paced him. There's no point in bringing up these other methods of detecting speed.
That's a question.
Hold on, Mr. Billingsley. So Mr. Billingsley is on cross. He's entitled to a thorough and sifting cross. I'll let him have a little leeway. Mr. Billingsley, when I feel like you're going too far, I'll stop you.
Thank you.
So at the time, I wasn't LiDAR or radar certified. I am now, and I can say that I would primarily use LiDAR. However, pacing is still a good option if need be.
Okay, which is the most reliable is what I'm asking.
I can't speak to that. I don't know the science on it.
You're trained in radar as well?
I am.
And laser?
Yes, sir. I am now. I was not at the time.
And pacing?
Yes, sir.
What are the requirements when you're learning when you're in training of pacing?
There is no
pace?
I'm sorry.
How do you train to pace? Is there depth perception and time and travel, all that's involved, right?
There's no specific requirements for being able to pace someone for speed.
No requirements for pace. Okay, that's a good answer. Was it dark?
Yes, sir.
Is it easier to pace somebody at night or in the day?
It's the same, sir.
It's the same.
Yes, sir.
Perception's no different. You know, I used to. Okay.
Objection, Your Honor. This is testimonial.
Okay. It's a question. Headlights. I'm asking him a question. Headlights look the same whether it's nighttime or daytime.
I wasn't looking at your headlights, sir. I was looking at your taillights.
Taillights too, to any kind of lights at night. Are the lights, they look the same in depth perception and distance at night as they do today?
Yes, sir. I've been on the same shift for the last 3.5 years.
I rest my case right there, and then
Sir, the state's actually presenting their case. Your case hasn't started yet. So,
Okay.
All right, Mr. Tipton, did you have any redirect?
I do, Your Honor. Officer Parks, were you wearing a body cam that day?
Yes, sir.
And did the body cam capture the entire interaction?
Yes, it did.
Would the body cam have captured the interaction where he said that he was doing 85?
Yes, sir. Which is why I wrote him for 85 miles an hour and not 90.
Your Honor, may I share my screen?
You may.
Okay, I just want to make sure we're sharing audio. Is the court able to hear?
Yes, I hear.
Hey, how's it going, man? I'm Officer Parks of the Clayton County Police. Hey, turn it down. turn the radio down.
Officer, I want you paying attention to it.
I'm clear. So, is there any reason we're doing 90 on the expressway?
Officer, I'm telling you, I was doing 85 according to this.
Okay, so 85?
Yeah.
I got you. You got your ID on you?
Yeah.
What's the speed limit? 65.
Oh, that's 65 here?
Absolutely. All day long.
Man,
There's signs all over the place.
I've been away from home for 2 weeks, and I've worked all. I just got off work, man.
I got you.
And I'm trying to get home, man. I'll tell you.
Where's home at?
Fitzgerald.
I got you.
I'm so frustrated and everything. Hold on, I got it.
Mr. Parks, what did that just show?
It showed Mr. Billingsley admitting to driving 85 miles an hour in a 65 mile an hour zone.
And what did he say? He saw that. What did he say he was going by to determine his speed?
His speedometer.
And did he give you a reason why he was going that fast?
He was just trying to get home. He'd been gone for 2 weeks and wanted to get home to Fitzgerald.
Thank you. No further questions.
All right, Mr. Billingsley, did you have any additional questions for Officer Parks?
Yes, there was. How many speed signs are on I-75? I mean, on I-65 that say 65 miles an hour?
I don't know exactly how many there are, but there's usually one at the beginning of the interstate and usually one after each exit. But I can't say for certain how many there were that night.
Yes. Could it be more than that, you say?
I really can't speak to how many were there that night. I can only tell you what there usually is.
Yeah. Did you tell me that they were all up and down there? They were marked all over the place?
Yes, sir, I did.
And but you don't know how many there were?
I don't.
Yeah. You're saying that they are many, though?
I'm saying that there's more than one.
Okay. At that point, more than one. Okay. What time of the day was this?
It was at nighttime.
Was there a lot of traffic out there?
No.
Okay. I cannot, well, I'm gonna, I've got more to say, but it's hard to do it in this kind of setup right here. So what's next?
All right, so we've finished with this witness. Mr. Tipton, did you have any other questions of Officer Parks?
No, Your Honor. At this point, the state rests.
All right, is Officer Parks able to leave at this time?
Yes, Your Honor. Thank you, Officer Parks.
Thank you.
Officer Parks, you're excused. Be safe. All right, so Mr. Billingsley, the state has rested their case. They've presented the testimony of Officer Parks. They presented the body cam evidence from the night in question. Sir, did you wish to give testimony in this? Please remember that as I instructed you, the state has the burden of proving the case beyond a reasonable doubt. You're not required to give any evidence or testimony. You have a Fifth Amendment right against self-incrimination. However, if you do want to give up that right and offer testimony and evidence, the court will hear it.
Yes, I would give up that right.
All right, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, I do.
All right, put your hand down, sir. Tell me what happened.
Okay. I was my argument here is there's only one sign. I went back and looked. There's only one sign that said 65, and you can easily miss it by one semi. There was two semis, that I was kind of traveling with. We were all kind of going the same speed. I observed this officer coming on to 675. I saw him coming on. So why would I speed? Why would I think, intention? Now, when he got behind me, he was about like a football field behind me, 300 yards. And then he was catching up with me. I shot, he pulled me over. So when he pulls me over, he, caught me off guard. He's like, what are you doing 90 for? I wasn't doing 90. I had been doing 85, and I know that was speeding because I was trying to get home in 75, and why would it be? It could easily be missed. That speed sign. There's only one, and he got. My argument is that is exit 2. He got on exit 2. And pulled me over before he got to exit 1. He got back off of exit 1. That's 1 mile. And I don't think he had enough time to accurately pace me, other than me being honest about what I was doing previously. I was never doing 90. Never. So his voice, when he come out there and said, you did 90, he was catching up with me. That was his speed. to catch up with you. He's never on my taillights. I would love to see, and I asked before when I came to the to say I wasn't guilty for the discovery of the vehicle's camera to show that would show his speed and when he got on and when he got off the ramp. He was only on for not even a mile. It was 1 mile between exit 2 and exit 1. And my argument is he didn't have enough time, Your Honor, to accurately clock me or pace me to get an accurate speed. Yeah, he did. He said he gave me what I admitted to, but that's what I had been doing before. Also, there's only one 65-mile-per-hour sign, as I went back and looked at it. There's not many, like he said. So there's just some inconsistencies here, Your Honor. Also, I have a CDL because I drive children. I'm the backup driver for the school swim team, and without me, there's not going to be a swim team. And that's what I'd asked him before when I was telling him about my CDL. Yeah, this is going to, like I said, now that was one of my concerns right there. My only concern, and I was willing to pay for that $100, was it being reported on my license, because for the school system, that's it. You can't do it. And I had a daughter that was on the swim team, and I was the backup driver on that. So that's what I was referring to him about. Wasn't about any other thing else. I have a good driving record, and I had been away from home for 2 weeks. I had all my stuff in that vehicle, and I was trying to get home. It was 2 days before Christmas. I had Christmas music going, and he hollers, "Turn that music off." I was like, I was trying to have a nice trip home. I had a 3-hour trip ahead of me. I drove 3 hours to get here. And, but I'm just saying there's some inconsistencies, and I did look up some case law about some that's been dismissed. I didn't bring that up, but at nighttime, you cannot have the depth perception he said was the same as it is during the day. It is not. I used to work on the railroad, and that headlight, you would think, is a mile away, and it's more like 100 feet away. You cannot have the same depth perception on you can say, and that is something that he said had made no difference. So that's another argument that I have right there. But just the inconsistencies, and that's why I'm here today, saying there, and the fact that it was a pacing ticket at night, no traffic, and it was a one speed sign could easily be missed. So, and that's what I have to say right there, Your Honor.
All right, Mr. Tipton, argument?
Yes, Your Honor. Your Honor, ignorance of the speed limit does not excuse one from driving the speed limit. The officer testified that there were signs at the entry and exit ramp for every entry and exit point on I-675. The court did observe the defendant admit to driving 85 miles per hour and admit that he had been viewing his speedometer. Your Honor, if we were to, if the court takes into, I think it would be inappropriate for the court to take into account the defendant's CDL, as Your Honor is aware of the anti-masking laws. Your Honor, based on the facts of the case, based on the defendant's own admission on tape, based on everything the officer stated, the state would request that the court find the defendant guilty of speeding 85 and a 65. Thank you.
All All right, so Mr. Billingsley, I understand the argument that you're making, but Mr. Tipton is correct. I could lose my position on the bench, and it would be illegal for me to consider the fact that you're a CDL holder and making my decision when the law, particularly when the law suggests to the contrary. The officer has testified that he paced you. He indicated that he paced you at 90. He pulled you over. When he pulled you over, it may have seemed like he was yelling to you, but to me, it appeared that he was just trying to be heard over the Christmas music. And so he asked you, hey, you were going 90 out there. No, I wasn't. I was going 85. And then there was the information about there being some confusion about the speed. However, the old axiom is that ignorance of the law is no excuse. And so even if the speed limit had been 70 or 75 on that highway, you still would have been exceeding the posted speed limit per the law. And so in this case, the court will find you guilty. The officer said he paced you at 90, but he did not write the ticket for 90. He wrote it for 85, which is the speed that you admitted. You also admitted that here in court, as you did on the body cam video. So the court is going to find you guilty of the speed of 85 miles per hour in a 65 mile per hour zone. And Mr. Tipton, do you have a recommendation for the penalty?
A $300 fine, Your Honor.
All right, Mr. Billingsley, I generally don't like to, give people a higher penalty just because they went to trial. So the offer, I guess, initially was $100 fine. The fine with the $100 fine with the surcharges would be $151.50. Did you wish to pay that today or have additional time?
Yeah, I pay it today.
Okay, so it's $151.50. When you leave the courtroom, you'll go downstairs to the second floor. When you come back through the double doors, you'll go to your left and you'll see the traffic court window. There they will accept your payment and they'll give you your paperwork as a receipt. And you'll be free to go after that time. Just don't leave the building without making that payment, okay?
Okay. They take credit card?
They do, sir. Okay. All right. Take
Thank
care.
you for your time.
You're welcome. All right, so I'm ready on the hearings for you said the Quan.
So it's going to be it says Denasia Morris, but it's actually Miss Denasia Korn is her.
Okay.
Yeah. So her last name's actually Korn, and I've got her. I've got her already pulled up, and I've also got and then Miss Amanda Stodgel is the other person who would like a hearing.
All right, so Ms. Korn, Ms. Stodgel, you can come on up to the computer so you can see better. All right, and Mr. Tipton, whenever you're ready to share screen.
Yes, Your Honor. I'll start with Ms. Korn. Can the court see? Is the court able to see, Your Honor?
I see it.
Thank you. Playing now. Was the court able to see?
Yeah, play it again for me.
Sure. Time's out.
Do we know what time of day this was? Okay, 6:36 a.m.
Yes, Your Honor.
And it was, okay. One more time for me.
Yes, Your Honor.
All right, Ms. Korn, tell me what you were thinking when this happened. What was going on?
She had put it in and then put it back out. So.
You mean she pulled over and then pulled out and pulled over again?
No, she in and then put it back out.
The stop sign?
Yes.
Like how long did she, were you stopped at some point and then she pulled the signs back and you started again?
Yes.
Where did you stop?
It was right before, it was like I was slowing down, but then after she pulled it back in, I just kept going. And then she pulled it back out.
So are you saying you just slowed down?
I have a witness in the courtroom. My mom actually worked for Clayton County School, so she was in the car. I was taking her to work.
Okay. So you're going to work, you see the buses pulled over, it's raining, you see the stop sign come out, go back in, and then come out and stay out. Am I understanding?
I was already passing by that point, so I mean I wasn't finna break and then.
No, just listen to my question. So you're coming, you see the bus pull over.
Well, she didn't pull, she was on the main road. She didn't.
Okay, so she was in traffic. Did you slow down?
Yes.
Okay, and when you slowed down and you were waiting for the arm to come out, arm starts coming out, what happened?
She pulled it back in and then she pulled it out again, so I kept going.
Okay. All right. Anything, Mr. Tipton?
Your Honor, review before.
Okay. So, Ms. Korn, I'm gonna go ahead and grant the appeal.
Okay.
But please be careful. I know it's kind of hard to judge what they're gonna do. Like I've had them pull over and then I'm sitting there waiting and then they'll wave me around and I'm like scared to go. But that has happened to me as a parent taking my child to school. So I understand that, sometimes they don't always follow the plan that we're expecting. So at this time, I'm gonna go ahead and grant the appeal, and you're free to go, okay? Please be careful.
Thank you.
You're welcome. All right, next for Sajil.
Yes, Your Honor, I'm pulling it up now. All right, Your Honor, I'm ready to hear.
Go ahead.
Okay. Does Your Honor also wish to see the still images?
Okay, Mr. Tipton, what am I looking for here?
It's just the video of the school bus of the not school bus of the school zone of the person driving in the school zone. They
Okay.
are the defendant is
The red car?
Yes, Your Honor.
All right, start it again. Okay, and what's the, what's the speed? That's on 138 Spur, right?
No,
Yes,
ma'am. It's 138, not Spur.
Yeah, right past, what's that, Stillwell Elementary, not Stillwell Elementary, it's,
When?
Yes, Swint Elementary. I know that route because my kid went to Calway. And I did that every morning. So okay, the speed limit at that location is, I believe, 25 miles an hour during the school zone. Is that correct, Mr. Tipton?
Yes, Your Honor, and this occurred at 7:59 a.m.
Oh, yeah. All right, so Ms. Stajo, what was going on?
Your Honor, I have video proof that the flashing lights go off at 7:58 on both sides.
At 7:58?
Yes, ma'am. They go off at 7:58 on both sides. So the side, because I just recently got multiple tickets. I go through 5 school zones every morning. So my kids go to Lake Ridge Elementary, and this is right by my house. That's
right.
And right here, I'm taking my oldest daughter back to Riverdale High School. But in this video that I have, you can see that on both sides, there's no, you see it just says school limit, a school zone. It doesn't have like the times on which you need to slow down or do the 25. So when we were at this one, it went off at 7:58 on both sides, the time. So it's not flashing at 7:59 when I get to this red light.
Okay, what speed was she clocked at, Mr. Tipton?
48 miles per hour, Your Honor.
And when it's not a school zone, it's 45.
What's the speed when it's not a school zone, Mr. Tipton?
Your Honor, if I may have a moment, I'll look that up right now.
Yeah, because usually if it's a speed zone and it goes down to 25, the not a speed zone speed is usually about 35 to 40. But if it is 45, it's
it could be 40. I'm not exactly sure, but I know when it's not a school zone, it's 40 to 45.
And I'm sorry, Miss Stajo, what high did you say this was near Riverdale High School?
This is, yes, Swint Elementary, SWINT.
Yes, ma'am.
Yep, right as you turn right.
So North Avenue is where I am. That's where I'm coming from. That's where the first pair of flashing lights is.
Okay, so she's coming down North Avenue, and it's right. It looks like it's crossing right in front of Crown Way towards Swint. I think you have to pull back because the flashing light starts backward on North Avenue, right at almost at that light where Crown Way is.
Yes, ma'am, it is the light.
Yeah, I'm very familiar with this intersection.
Yes, ma'am, me too. I go through it every morning. I go back and forth. I take my little kids and then I come back and I take my oldest daughter. So I go, and then I go through their school zones as well.
Yeah, as a mama, you get to the point where you try and minimize the school zones that you have to drive through to get to the various schools.
Unfortunately, there's no way around it. So I have to just make sure that I'm always doing 25 when I go through the school zones.
And I'm sorry, Your Honor, you were trying to.
I'm just trying to see where the speed, yeah, that's when flashing. But what's the speed when it's not?
The speed limit on the street is what she's trying to find.
Yeah.
I think there's one a little further up.
Okay, Mr. Tipton, if it's this hard for us to determine what the non-flashing light speed limit is, I'm gonna go ahead and grant the appeal. Ms. Stajo, just be careful, okay?
Thank you.
You're welcome. All right, so, Mr. Delarme or Delarme, are you back in the courtroom, sir?
I'll go grab him, Your Honor, and I'll get that other person's,
I'm sorry.
Your Honor, I'll go grab him and I'll get the other, gentleman's email as well, Mr. Kelly's email.
Okay, thank you.
Can we go over the calendar once again, Judge? I'm sorry.
Okay, no problem. Holton, that's a fine, 90 days to pay. Delarme, we're still waiting. Dorr continued to September 15th. Ford, appeal denied. Humphreys, appeal denied. Kelly, a fine, 90 days to pay.
Thank you so much. Have a great day.
Korn, which is also Morris on the calendar, the appeal granted. Sajil, the appeal granted.
Got it. Thanks.
Thank you.
Excuse me.
Yes, ma'am.
This is Ashley. I was wondering, is I'm able to go or I need to wait?
No, Miss Ashley, as long as you've provided us with your email address, you're free to go at this time, ma'am. Just check your email. You'll have 90 days in which to pay, and you should be able to pay through the citation that you got should have instructions on how to pay.
Okay, thank you.
You're welcome.
I got up here.
Your Honor, state's ready on the, Kelly case.
Ready?
Yeah.
Mr. Kelly, if you could come to the podium, please.
Okay.
Your Honor, are you ready?
Yes.
Thank you. Mr. Kelly's vehicle is this vehicle right here.
Okay, the second vehicle that went by?
Yes, Your Honor.
All right. Do that one more time. Yeah, I'm gonna grant the appeal. He was too close to be able to stop when the stop sign came out.
Okay, Your Honor, thank you.
Right, and that was Mr. Kelly?
Yes, Your Honor.
All right. So Mr. Kelly, appeal granted.
Thank you.
You're welcome. Just be mindful, Mr. Kelly, when you see him pulling over, that you might need to slow down and prepare to stop. They don't always put the stop sign out, but it is a likely result of them pulling over.
Okay, thank you.
All right, you're welcome. Next.
Is the court ready?
I'm watching.
The only vehicle passing is the defendant's vehicle.
Okay, run it one more time. All right, so at the time the video started, the vehicle was far enough away to have stopped and the sign was already out, so the appeal is denied, and Mr. Delorum will pay the fine.
Your Honor, I did speak to Mr. Delarme previously. He is on a fixed income, and the state was wondering what the longest amount of time the court could give Mr. Delarme to pay would be.
He's on Social Security, Your Honor, on a very fixed and low income. And we were just questioning, even without the arm being out and being daytime, he just wasn't aware, didn't really know with the bus being in the turning lane and there was no arm out. He wasn't aware of the bus on his side because he was on the opposite side. There's still no way to appeal.
Okay, the bus being on the opposite side, you still have to stop. The only way you wouldn't have to stop is if there were an obstructed median, meaning there were trees, grass, flowers, concrete barrier, some median that could not be easily crossed by a vehicle. So when you have a median right here, that's just really a center turn lane, you still have to stop on the other side of the street. And at the point where the vehicle is, as it stopped right now, he's far enough back to where the stop sign is out. Even if he had stopped parallel to the stop sign, I would have still allowed the appeal. But he continued going once and the stop sign is clearly out. So I can give him up to 90 days to pay.
Is that the longest, Your Honor? Because he's $1,100 a month Social Security and his expenses. I'm helping out, and you see I'm here today, so I was just hoping we could give me
120 days.
120 days. Yeah.
Yeah.
Okay, ma'am. That'll be helpful if that's what you.
All right. Thank you. All right. So, Mr. Tipton, when you give me the orders, I'll go ahead and sign those, and we can get them out to everybody by email.
Yes, Your Honor. Thank you.
All right. Thank you.
And how do we go about paying on the 120 days? The same information on the citation?
Yes, sir.
And it'll be extended for 120 days? All right.
Yes, sir.
Thank you.
All right. Thank you, sir.
Come on, Dad. All right, you too, man. You have a great disposition.
Thank you so much. Bless you. I'll see you. Okay. Thank you so much.
Come on, Dad.
All right. Anything else at this time?
Your Honor, if I may quote the gentleman from the bench trial earlier, think of the swim team.
All right. All right. Thank you, Deputy. I think that concludes all of our calendars for the day. Did you have anything for me, Mr. Deputy?
No, that was very
Okay.
very merciful. Very merciful. That was very nice of you, Judge.
I do what I can. Do what I can.
Yeah,
All
the
right.
prosecutor as well, and the prosecutor as well, because he's the one that first brought that up. I really respect that. I'm not in the courtroom a lot, but I really respect both of you for that. Mercy, grace and mercy. I love it.
Well, our team as a whole, defense, state, we all work really well together to, I guess, marry justice with mercy. So I think that's kind of like why I like this job. Everybody has good common sense.
Yeah.
All right.
I'm very impressed.
Thank you. All right, everybody take care. Thank you so much. I'm still signing, and I'll try and get
Okay, Miss McMahon, come on up. So we have several things to talk about. Let's talk about the cases we haven't seen you on yet. So on April 3rd of 2025, you received citations for failure to maintain your financial responsibility, second, and driving without a license. If you plead guilty or no contest to those, I'll find you guilty. I'll assess fine and court cost of $733 on the no insurance. Give you 2 days jail credit. Your balance would be $433. You would be time served on the other case. Yesterday, you received a citation for speeding 75 in a 45-mile-per-hour zone.
I was going off.
Failure to maintain financial responsibility, second. That's a $648 fine and court cost, and no driver's license. If you were to plead guilty or no contest to those, you would have a balance of $34 on the speeding, and $348 on the no insurance, and the other case would be time served. Your balance on these cases, $815. If you plead guilty or no contest on those, I would release you from jail to appear here at our court to set up a payment arrangement on the $833. What do you want to do on those?
Guilty.
On all 5 of them? Okay. Okay, let me get that paperwork done. Give me a second.
I have a question as well. Is there any way that I could get like a form where I can go back to work, like driving back to work, so I don't get in trouble for that until I get my license?
Yeah, you can get an occupational driver's license.
Yes, ma'am, that's what I was gonna ask for. And do I go to the DMV to get an occupational license, or where do I go to get that?
Have to go to a justice of the peace.
Okay.
You live in Potter or Randall?
I think Randall or Potter.
Yeah, I'm not familiar with this address. Do you live on Bryan?
No, I live on 2102 South Washington Street.
That's Potter.
Oh, yeah, okay, that's Potter.
We have information at our court, so when you come to our court, we can give you information about how you can get an occupational driver's license. You have a tough road to hoe because you have a lot of citations, but you can do it.
Of course.
Where do you work, ma'am?
Hillside Heights,
Or what do you do there?
laundry.
How long have you worked there?
I worked there for a month, 2 months, because I started in April.
Where'd you work before that?
I was just cleaning houses. I wasn't like,
Okay. You still have your job?
yes, I do. I just have to call her and let her put me on the schedule.
Do you support any dependents?
No, ma'am, I do not.
Do you receive any form of governmental assistance?
I received food stamps and I'm trying to I applied for HUD. And I'm supposed to do utility stuff to have my gas.
Why have you had these financial struggles? Like, what's
I
going
just had ovarian cancer, so I haven't been able to pay anything. And I've been struggling really bad. I'm also about to lose my house as well. Because I can't pay anything.
I don't understand, you didn't come in on these tickets until we saw you in jail in March.
I was
And
go to viral court to see y'all the other Thursday, but I ended up working super late, so I couldn't come in. And then I emailed y'all and let y'all know that I wouldn't be able to pay anything until June, which is now. And y'all said, okay, and that was all that I got out of the reply. I was supposed to go up there today pretty much and talk to y'all and see what I could do about them, but I'm here.
okay, let me look at it from my perspective, okay? Because I think our perspectives are a little bit different.
Okay.
So we saw you in jail on
Yes.
these cases from 2022 and 2023. We
Yes.
we saw you on these in March.
Yes, and
When you came, I'm not asking for a response. I'm just giving you some narrative here. You were found guilty, you were given the appropriate jail credit, you were released to appear here at our court. You came to our court, you set up a payment arrangement. Your payment arrangement was, and this would have been one that you set up because I can tell by looking at the amount that you were involved in this. 8 payments of $250 bi-weekly, because that's what you were going to pay. Is that all sounding familiar?
Yes, it is.
Okay. And then I don't think you made a payment.
No, ma'am, I was supposed to come back and figure everything out, and then I ended up getting those. I got them in the mail though, and I was supposed to send them back and
You got
pay.
what in the mail?
The ones that said no contest and then are not showing up to court, and then the
Hey,
other
we're talking about apples and oranges.
Oh,
So when you were let out of jail, you were told you saw Judge Cates in jail, you got out of jail, You set up this payment arrangement of $250 biweekly.
Yes.
You did not keep up with your payment arrangement at all. We sent you, this is all before you got your new tickets. So
Yeah.
this is apples, that's oranges. On these tickets, you still you didn't make a payment. We sent you, because you didn't make your payment, we sent you what's called a pending warrant letter to the house on Washington Street.
Okay.
You had 10 days from the date of that letter, and it says your payment plan must become current within 10 days. That was your $250 that you told us you were going to pay. If you can't bring it current within 10 days, you must appear and speak with the judge before the 10th day.
Okay.
So you had until March 30th to come back and talk to the judge. Well, you ignored that. You didn't come talk to the judge. And then we sent you what's called an order for show cause, telling you to appear here at our court. We said, hey, we need to see you in person.
Yes.
You're ordered to be here. And you didn't come to that. So when you ignored the pending warrant letter, then we took the next step and said, we're ordering you to be here.
Yeah.
We sent that to you, and you were supposed to be here I sent that to you on April 9th, and you were supposed to be here on April 28th on those.
Email.
No, be in person. Be in
Oh.
person. Come here in person. And then you didn't come in person. Well, in the meantime, you got those new tickets on April 3rd, which you still ignored. And I don't understand why somebody who had a month earlier been in jail for tickets, who has life hurdles the way you apparently have them, chose to ignore the tickets again. I'm struggling to understand why you set up this incredibly optimistic payment plan and then didn't do anything, and then ignored your new tickets. Help me.
No money at the time, to be honest.
Then why would you set up a payment plan like that?
I don't know. I thought that I could have the money, but I guess I just didn't. I also didn't have a job at the time, and I was looking for a job, thinking that I could get a job and pay, but that didn't work out either.
You know, we're like the easiest people to deal with. We give you some flexibility, but don't come in here and blow smoke thinking it's going to make me feel happy and I'm just going to love to hear $250 biweekly when that is not your reality. My goal is to not have to see you. You get a ticket, you come in, you set up a payment plan, you follow that payment plan. But don't set something up just to make me feel good. Miss McMahon says she's going to pay $250 biweekly. Well, then if I have to see you every 2 weeks to adjust it, let's just be realistic.
Yeah.
So I'm going to give you one more try, but it's not working to your favor that you don't want to follow the process. And the process is, I'm the judge, you're the defendant, a repeat offender, and you've never followed the process. So here's the process. When you get a ticket, you have 12 days to come into court. We're not going to throw you in jail. Just come to court. Okay? Don't write me or call me. Get in here. When you set up a payment plan and you can't follow it, don't write me or call me. Come back and see me. And like you're sitting here requesting virtual court, we don't want to see you on virtual court. We want to see you in person when you have gotten so far behind and you have warrants. So don't wait until you're getting threatening letters. As soon as you can't comply with the court order you come see me. But let's come up with a realistic court order so none of that ever has to happen. I'll be as upfront with you as I want you to be with me. Does that sound fair? Okay. I need to see you by tomorrow at 2. So don't write me or call me and tell me you can't be here.
I'm gonna be there. at 2.
Okay. Okay. And if you want to come at 11, you can come at 11.
Okay.
I'll see you tomorrow. Mr. Noble, you'll come up here, please. Hi, Mr. Noble. I'm Judge Hamilton with the Amarillo Municipal Court. Seeing you today because you were charged with public intoxication yesterday. It's a Class C misdemeanor punishable by fines of $1 to $500. You have the right to hire a lawyer. You have the right to tell me you want to have a trial. You can choose to have a trial in front of a judge or in front of a jury. You don't have to make that decision today. But today I want to know if you want to enter a plea of not guilty to that charge. Guilty or no. Go ahead.
I don't know if I should plead guilty or not. The fear of my he makes me. I've usually told I've ever leaned towards that. I've never done that before with the smoke, and but I have to tell on him, and it would be maybe put me in. I don't want to tell, but I should tell because he got me to smoke it. That I stayed with him and chewed me up and stuff.
Yeah, it sounds like somebody gave you something crazy.
It was a bowl of crystal meth, and I never usually ever did that. They raped me a few times, they charged me, they chewed me up. William Byard third and William Byard third and
Oh my gosh. Did you tell the police that?
I was scared to talk to the police ever sit there and tried to kill me in Oklahoma, tried to sentence me to life, to torture, to behind bars, that for something I didn't do, and I'm from a Greyhound bus. And then I was scared of the police because wasn't scared, but they always left me alone while I was walking or doing my job. This time I was out of control. It was 3 days. I was 72 hours up for 72 hours.
Where were you for 72 hours?
And I went by the Catholic Church, Roman Catholic, by in Washington Street.
At these people's houses?
Yes, on but William Byard the third's house.
Are you in danger now?
I'm not in danger now, but I just need to be fed. I need to go. I need to something to do something.
Do you want me to just talk to you tomorrow? Do you want to try to talk to a mental health counselor?
So, may I talk to you now?
You can talk to me now, but I don't know what all I can do for you. I can try to get a mental health counselor to talk to
I
you.
was wondering if I get real privileges, like 3 meals a day privileges.
Well, they'll give you a meal. I mean, Saldivar, has he been fed today?
Have you eaten? I haven't eaten today.
Okay, well, they'll have lunch here. Here in about an hour or so.
Do you want to eat and let me talk to you tomorrow?
May I still talk to you? This is very important to me. Please let me talk to you.
Well, you can talk to me, but I'm not a mental health counselor. I'm a judge, so I'm probably not the person you want to talk to.
Hey, you are the judge. I understand completely. Please talk to me.
Well, the other thing you could do, Mr. Noble, if you wanted to plead guilty or no contest to public intox, you could, and then you can choose to stay in jail if you want to. You would just stay there for a couple of days, but it's up to you.
What's my option?
Well, you can get out of jail. I'm happy for you to get out of jail, but I'm worried because it sounds like you want.
I'm going to Bay City Mission with the facility. They have 3 meals a day. I would take care of me there at Bay City Mission. It's another
Will Faith City Mission let you go back?
Can you ask, I'm sure, I'm 100% positive they will, but you ask them if they, can we
Could you,
communicate with them?
Mr. Noble, if I let you out of jail, would you call Faith City Mission and see if they could let you back?
Yes, ma'am, 100%.
Okay, but you'll have to come see me. Could you come see me at court?
Yes, ma'am.
Okay, well, I'm gonna let you out of jail today. Saldivar, can somebody see if they can call Faith City Mission to see if they'll help him? I think he's on the phone. Hold on just a minute, Mr. Noble. It's okay.
I'm sorry.
You're okay. Obviously, you're very scared. Hey, Deputy
I
Saldivar,
was trying to get away from.
he would like to know if somebody could call. He wants to go back to Faith City Mission if they'll take him. So I'm gonna give him a PR bond. Could y'all see? Could you like somebody help see if they could get him to Faith City Mission?
Yeah, for sure. We can work that out.
Okay. Okay, Mr. Noble. Good luck.
Thank you.
You're welcome. Now, don't forget you have to come see me, okay?
Yes, ma'am.
Okay, thank you.
And 12 days?
If you get out today, you need to see me tomorrow.
Huh? In the morning
Okay.
or lunch? Or,
He's gonna give you a piece of paper. It tells you where you need to go and what you need to do. Thank you, Mr. Noble. Thank you. Okay. Drink some water. Stay clean. Don't talk to strangers. All that stuff.
do the program at Basic Vision.
They have a good program there, okay? I'm just worried about you with some of these strangers you've been around.
I was,
Do you want to go to Faith City Mission?
yes, I will.
Okay, go with the deputy. He'll help you out, okay?
Thank you.
Thank you.